Good morning or good afternoon. I'm uncertain when this is playing. My name is Mark Lanier, and Lisa asked me if I would give a video presentation of what I believe makes a gold medal judge. And I'm delighted to get to do it. I wish I could do this live, but as I understand it, at least the first time this gets played, I will be trying a case in front of one of those gold medal judges out in federal court in Southern California. So instead, you're stuck with me by video. I apologize for not being there personally, but I hope that this video is of some use to you. This is an official state of Texas judicial chair. It was a gift to me, and I look at it every day that I'm in this office. I look at it and wonder, what would it be like to sit in this chair as a judge? I've got no clue. I can tell you that the people who do judicial work are truly some of the most important public servants in our country. And yet there's some of the people that I believe don't get the credit and the recognition from the public. So if you're a judge or you're thinking of being a judge and you're watching this video, I would like to first say thank you for your public service, your interest in public service, and your interest in justice. It is what makes our country unique. It is what makes our country America. So with the niceness out of the way, let me get straight to the point. I've thought of 5 traits that make for an effective judge, and normally I would give you a PowerPoint presentation to go with each one, but I don't have PowerPoint available for this video. So instead, we're doing old-fashioned PowerPoint, whiteboard and marker. Number 1, a gold medal judge is a judge that is polite. I'm starting with manners. Maybe that's because I grew up in Lubbock and my parents taught me that manners were most important. But politeness is critical. I've seen it from both ends. I've seen the judges that are polite, and I've seen the judges that are disrespectful and frankly, it's distasteful. It's a bad experience. It's a bad experience all the way around. So let me first tell you, the polite judge. Here's a wonderful illustration. I learned this early on. I was a young lawyer at Fulbright and Jaworski, and I was sent down to Laredo, Texas to appear in front of a federal judge for a partner who didn't need to go to the hearing, could just send me. And I went down there. I was the eager young associate who showed up at court 30 minutes early, wanting to make sure I was there on time. I got a good seat. I knew when the docket was going to be called. I knew all of this stuff. So I get there, and there's only one other fellow in the courtroom. And he's dressed nice, but he's not dressed like a lawyer. So I'm thinking maybe he's a client, not a lawyer. But I sauntered up to him and asked him if he was there for something. He says, yes, I'm here for my hearing, and I've got a hearing in front of the judge, and I'll be making my argument. And I said, well, that's fascinating. I said, I'm here for a hearing as well. I've got an argument to make, and I guess the courtroom will fill up. And we continued to visit for a while. Guy seemed great to me. I sure enjoyed my visit with him. Well, the federal judge takes the bench and he calls the docket. And by this point, the courtroom's filled up. And most of the lawyers are there in proper lawyer attire with their tie and their coat. And I was wondering why that fellow was not dressed, at least in the way we would dress in Houston. But I wrote it off to being in the Valley. The judge takes the bench, and the first matter the judge calls is my newfound friend. And the judge calls his case before the docket. It turns out that this man was not a lawyer. He was an airplane pilot who had lost his FAA license and was appealing through the court system to get that restored. I was thinking about it as the judge called him before the bench, and the judge says, frankly, I have a problem restoring your license. The man said, Judge, what's the problem? And the judge said, well, the problem is you lost your license because you've been deemed insane. And the man said, but Your Honor, I'm very sane. That's why I'm here. I'm here to show you my sanity and to demonstrate it for you, and I'd like to put on a showing of that. And the judge, very kind, very respectful, said, but sir, you've kind of shown me that simply by the letter you've written asking for this hearing. The man said, well, what's wrong with me writing a letter asking for a hearing? And the judge said, well, there's nothing wrong with it, and I appreciate that you did that, sir, but you carbon copied the President of the United States and asked him to please show up and testify to your character and your sanity. I was just amazed at this point about two things. Number one, that I'd spent time with this man in the courtroom alone before the bailiffs got there. Number two, that this judge was so kind and so respectful to this gentleman. And the gentleman said, well, Your Honor, I think if the president testified to my sanity, you would have to listen to that. And the judge said, well, I would, but do you know the president? He said, well, no, but I've written him and I'm hoping he'll be here. And the judge said, but you see, that's not really normal behavior. And the man said, I'm a citizen of this country. Am I not allowed to write the president? The judge said, well, you certainly are. But it goes deeper than that. And the judge continued. He said, I notice you've also CC'd the Pope and asked the Pope to come testify to your sanity. The man said, yes, Your Honor. The judge said, do you think the Pope's going to be here? The man said, well, I've looked around the courtroom and don't see him yet, Your Honor, but he may show up. The judge said, do you know the Pope? He said, well, no, I don't know the Pope. But and the judge said, well, then how do you think the Pope could testify to your sanity? The man said, Judge, he's the vicar of Christ. He should know if I'm sane or not. The judge said, I am so sorry to do this to you, but until you get a licensed professional psychiatrist to testify to your sanity, I'm not going to be able to restore your license. Have a good day. It impressed me as a young lawyer very early on. This judge was the epitome of polite. And I won't go into the examples of the judges who have been so impolite, but I will tell you about being in a courtroom where a state court judge was conducting a trial, and a legal assistant for one of the legal teams had her cell phone go off, and the judge just went ballistic and not only berated her in front of her bosses, berated her in front of the jury, but ordered that she go stand on the courthouse steps in the presence of a bailiff and sing the Aggie fight song. She started crying, and it did nothing to relent that judge's anger. Politeness makes for a gold medal judge. Number 2 on my list of what makes a gold medal judge, a simple 4-letter word: fair, impartial. This is true not only on a trial level, it's true on an appellate level. I think a number of plaintiffs' lawyers would agree with me that we've been to mediations where, true or not, the perception among the bar is that there is a great deal of unfairness on an appellate level. A number of people have put on PowerPoint presentations at mediations. I've had one be so bold as to say, Lanier, you're the plaintiff in this case. You've got the facts on your side. You've got the law on your side. You've got damages on your side. And then with a PowerPoint slide flashing on the wall, they show a picture of our Supreme Court. And they say, but it doesn't matter because we have the Supreme Court on our side, and that trumps the law and the facts. Now, I can't quite go there and agree with that assessment, but I can tell you that that goes on in Texas on a regular basis. And if that perception exists among the bar, then something is tragically wrong. And I don't think all lawyers would go so far as to say that that was an accurate assessment, a fully accurate assessment of Texas courts. But I do think most every trial practitioner in this state recognizes that politics does enter the picture at some point. And it should not. A gold medal judge is a judge that will rule against the judge's own interests if justice demands it. A gold medal judge is a judge that doesn't think politically in making decisions, that doesn't think ideologically in making decisions, but follows the law in a fair and impartial manner. I tried a case in New Jersey. I've tried several up there, I guess now 3. I tried a case in New Jersey, and the first time I tried it, I was in front of a judge, Judge Carol Higbee, in Atlantic City, New Jersey. And getting ready for that trial, I spoke with a number of local counsel. I said, okay, tell me the politics. They said, what do you mean politics? I said, well, tell me, the political landscape. What do I need to know to maneuver as safely as possible through the court systems of New Jersey? They said, well, it's not really politics. It's just the law. Just follow the law. I said, I know, but are your appellate courts, do they lean to the plaintiff's side, which Texas courts have done in the history when the pendulum was on the other side? Or do they lean to the defense side, as some would argue some appellate courts do today? Where does the pendulum sway? The man looked at me like I'd been drinking funny juice. He said, they just follow the law. And I didn't believe him. But I was stunned to find out that seems to be what they do. And you don't have to sit there and think, okay, how am I going to be wrongly affected by some new incarnation of the law or some new rule or some new procedure that would invalidate the finding of our jury? Fairness, gold medal trait number 2. Gold medal trait number 3. And this is one that's a little bit dicey. In fact, it's dicey enough I'll write it in red for you. And by dicey, I mean it's not always all it's cracked up to be. But here it is. Gold medal trait number 3. A judge who is prepared. Now, preparation can be taken to an extreme. I've now argued multiple hearings in front of the judge I'm about to try this case in front of in Southern California. We had to submit our motions in limine ahead of time. We had to submit our Daubert motions in paper before the arguments, other similar trial motions. And the judge set a hearing on these motions where I had to come in and argue the motions in limine. I had to come in and argue Daubert. Before each hearing, the judge issued, and in the Daubert situation, a 50-plus page tentative ruling. Motions in limine were 15 pages, tentative rulings, where the judge went through and ruled on each one with reasons for decision, but only in a tentative fashion and simply to help the lawyers be prepared to make the best substantive argument we could during the hearing. In both cases, the judge wound up changing his mind on several of the points by the time he entered the final ruling. That's preparation taken to the extreme. I've never seen it before in 30 years of practicing law. It's really nice, but I do not expect it. I don't see how anybody could do that on a regular basis. It's amazing to me what this judge does. But there are still opportunities for judges to be prepared, whether that means reading the pleadings ahead of time, reading the briefing ahead of time, or not. Now, when I said this idea of prepared as number 3, I said it with a bit of wishy-washiness in my voice. The reason I'm a bit wishy-washy about it is some judges do extemporaneously better than they might ever do with preparation. Some judges are just really good at ferreting out when and where they need to spend their time preparing. And to spend 30 minutes or 45 minutes reading a motion, when the odds are before the hearing both sides are going to come to an agreement and that motion is going to be resolved anyway, is to some degree a waste of time, especially if the judge recognizes that they'll be able to immediately assess the arguments and determine who should win, or hold those arguments in their brain while they go read the briefing afterwards. So I'm not suggesting that everybody do what this federal judge is doing in Southern California. But there is something about, as a judge, being prepared, at least knowing what the case is about, remembering who the parties are, or remembering who the lawyers are, that really assists the lawyers in knowing that things will be done in a timely fashion. So that's number 3. Let's go to number 4. Number 4 is not going to fit on my board very well, but I'm going to try it anyway. Let's see if we can do it. It's rather long. Let lawyers be, you ready? Lawyers. Sounds obvious, but maybe it's not. So I was trying a case in a court up in the Northeast, a federal court. And the judge was polite to me. She recognized that I was a Texan and that maybe we had a little different way of doing business in Texas. Though I do try cases around the country. Before opening, each side exchanged their PowerPoint slides. I had some pictures in mind. I'm a big believer in pictures. I think pictures communicate in a way that, and keep attention in a way that words alone do not. So I had my PowerPoint ready to go. My pictures weren't argumentative. They were just illustrative of the points and the captions that went with them. The difference between saying it's hot outside and saying it's hot outside and having a picture of a thermometer that shows 102 degrees. That's an example. That wasn't in our case. We weren't trying a case over the temperature. The judge looked at my pictures because she got a copy of the PowerPoint as well. And she said, Mr. Lanier, please approach the bench. I went to the bench and she said, are you serious about showing pictures in your PowerPoint? I said, absolutely. She said, well, I want to tell you that here in the Northeast, I won't name the city, we have a jury of a much higher intelligence than you're probably used to in Texas and other places where you try cases. And here a jury would find pictures to be insulting, as if words aren't adequate alone, and I'm not going to have you insult our juries. I said, that's fine, Your Honor. It's your courtroom, and I'll follow whatever rules you've got. I might add, this was a federal courtroom, and the judge did not let the lawyers participate in voir dire, or voir dire as they call it, jury selection. So the judge picked the jury, allowing us to exercise a strike here or there, and had impaneled this jury. I gave my opening without any pictures, just with words. The defense lawyer did the same. I put on my first witness, and we went into day 2. Day 2 arrived, and the judge called us to the bench before the commencement of trial. Yes, Your Honor. Judge says, well, we've got a problem with one of our jurors. Well, what's the problem? Well, the problem is our juror evidently cannot read or write English, can't really understand English, probably shouldn't be on the jury, in fact, shouldn't be on the jury at all. And this was a juror in the land of the intelligent that didn't need pictures, evidently, but somewhere between the juror and the judge's voir dire had gotten onto the panel someone who couldn't understand or read a lick of English. And in my heart of hearts, I just kept thinking, gee, at least she would have gotten my pictures. Of course, that's not my place to say that to the judge. But what I will say is let the lawyers be lawyers. We live in the 21st century. Things are so different than they were when I got out of law school in 1984. We have computers, we have Elmos, we have all sorts of tools that help lawyers communicate. Juries are asked to address very serious questions. And lawyers have an ability, and it's going to happen more and more as time continues to grow. Lawyers have an ability to use innovative ways to teach and to illustrate and to persuade. It's highly important. Tim Elmore, in a book called The I-Y Generation, referenced a study that indicated that the generation that is right now in jury service, people who are 18 to 25 in age, they're called screen-agers by some because they grew up with screens in front of them. They had screens on their cameras. We didn't when I grew up. When I grew up, if you wanted to take a picture, you looked through the little hole in the camera. They have screens on their telephones. When I grew up, the telephone was this big clunky thing that was shaped like a banana with tumors at each end. They have screens everywhere they go. Screen-agers. So the juror who's age 18 to 25, here's the statistic that Tim Elmore gave. For every book they read, they watch 35 movies. That statistic stunned me enough that I did a site check to see if he got it right. For every book they read, they watch 35 movies. We are seeing now, but we will continue to see a transition in the way people present cases. PowerPoint is a great example. I was trying a case, in fact, it was the second case I tried in New Jersey in front of the same judge, Carol Higbee. The defendants in that case got ready and gave their closing argument. In New Jersey State Court, the defendant goes first in closing argument and then the plaintiff. So it's not plaintiff, defendant, rebuttal. It's defendant, and in essence, the plaintiff just has one big long rebuttal. So we had both prepared our PowerPoints the night before, a major case, a lot of media in the room, in the courtroom. The defendants get up and they give an hour and a half closing argument, complete with PowerPoint. Two of their PowerPoint slides I thought were quite deceptive, and they left room for me to be able to show the jury clearly a level of deception. So with those two PowerPoint slides, while the defendants are giving their presentation, I recreated their slides on my computer. I inserted them into my closing PowerPoint. I took those slides, one of which was a timeline that had messed some things up, and I animated the slide so that I could first show the slide as the defendants had used it. Then I could take that slide and with a push of my remote control button, I could start moving the different images around on the slide to put them where they belong. It made a graphic point to the jury, but what I found most interesting about the entire affair is after my closing argument was done, the judge had charged the jury had gone back to deliberate. The lawyers for the other side had me approach the bench and ask the judge to alert the district attorney and to alert the state bar and to put me on oath because they believed that I had sent a mole or somehow ferreted out the night before the slides that the defendants would use, because I had integrated 2 of their slides into my presentation. The judge said, I don't think Mr. Lanier would do such a thing. And I'm not going to convene a grand jury or send it to the DA or report it to the state bar. Now, we're done. And I said, Your Honor, time out. We may be done, but they've just made a record of these accusations, and I appreciate the fact that you don't think I would do it and that you are inactive as a result and standing down. However, I would like to go on record and say that whomever they had make their slides just use the basic template slides that are available in PowerPoint. And while I was sitting there, I recreated the slides. And I'd like the record to reflect that. And I'd like the record to reflect that PowerPoint gives a time signature so you can see when these adjustments were made. And I will let them or anyone else who wants to look at it and see that I made those slides on the fly while they were being presented by the defendants in their closing argument. Technology is a wonderful thing. It's going to change the way we do business. It already is. But let lawyers be lawyers. Let lawyers be cutting edge. Let lawyers do these new things. And let the wonderments of the 21st century enter the courtroom and affect business. So that's number 4, let lawyers be lawyers. Now my last one on the heels of let lawyers be lawyers is pretty simple. 3 words. Be a judge. Yes, be a judge. Make decisions. Don't worry about hurting people's feelings. You can make decisions and be polite or be impassive about it. Just be business, matter of fact. But make your rulings. If you're right, theoretically, you get upheld on appeal. If you're wrong, theoretically, you get flipped on appeal. Nobody's going to call them all right. Nobody's going to call them all wrong, but make decisions. And don't be afraid to run your courtroom. Still allow the lawyers to be lawyers. But sometimes a judge needs to enter into the picture. There's a federal judge in Dallas that I'll not name who got wind of a deposition that we had taken in a big piece of litigation that goes out nationwide. And it's a consolidated action in front of this federal judge in Dallas. And both sides were complaining of the other side's behavior in this deposition. It was a deposition videoed for trial, and there were lots of what one side assumed were silly objections that were just being made to disrupt the deposition and the flow, make it impossible to cut a video effectively and show a deposition. Arguably, the other side thought that the one side doing the questioning was doing it either hyper-aggressively or disrespectfully or at least with sidebar interspersed against the lawyers. And somehow this deposition in its video form made it to the federal judge. The judge watched it, and the judge was not happy with several things the judge saw. The judge had no problem calling the lawyers into his courtroom and addressing the behavior the judge did not think was proper and rectifying it with the promise that if the lawyers did not follow his behavior, they would not be practicing on this case or any other case in his courtroom. He expects the lawyers to be lawyers, but he will be the judge. I got to tell you, that has turned into one of the cleanest cases to work in that there is, because all of the lawyers have recognized who's wearing the black robe and who's simply in dress clothes. The judge being the judge is a good thing. It can be done respectfully. It can be done impartially. It can be done fair. It can be done with preparation. But being a judge, ultimately a gold medal judge, means being a judge. So those are my 5 suggestions. You've been kind to listen to me. If you've been asleep or you notice your neighbor's asleep, now's a good time to wake them up. Say, Lanier's done. You can wake up. This seminar is now going to get interesting. Thank you guys again for your service. The women and men who serve in our judicial system are doing a yeoman's job of serving the public and making America great, one courtroom at a time. God bless you guys.